Hi, everyone. I hope you're all doing well this week. The LICM is back this Monday as promised with a short video on employment and everything you need to know about working in Quebec. So my name is Juliana. I'm the Director of Community Services at the clinic, and I'll be introducing you to some key rights that you should know about if you ever plan to work in Montreal. If you missed our first two videos, where William, our Executive Director at the clinic, explains all the free services we offer, and Alexa, our Director of Communications, tells you about renting in Montreal, don't forget to check them out after this. So I'm going to share the presentation and we'll get started. Now, before we get into the substance of the presentation, I wanted to take a moment to acknowledge the ancestral lands that the LICM is located on. So the LICM is located on the traditional territory of the Kanien'kehá:ka and Anishinaabe nations, a place which has long served as a site of media and exchange amongst nations. We recognize and respect the Kanien'kehá:ka and Anishinaabe nations as the traditional custodians of the lands and waters on which we meet today. Also, before I begin, I have to let you all know that in accordance with Article 128 of the Act respecting the Barreau de Québec, only lawyers and notaries can give legal advice in Quebec. So as law students, we can only provide information. So nothing in the presentation should be construed as or relied upon as legal advice. All right, so let's get started on the topic of employment law in Quebec. This short video will cover the following topics: what to look out for in the employment contract, rights and obligations in the employment period, human rights in the workplace, and the end of employment. So Sam just finished his first year at McGill, and he's getting ready to spend his first summer in Montreal. Sam is excited because he managed to find a job related to his field of study. This is his first serious job and the first time he will work in Quebec. His new employer sent Sam his contract by email and expects him to review and sign it. Sam has never read an employment contract before and is unsure what to look out for. So here are some of the basic rights that an employee is entitled to and should be reflected, therefore, in their employment contract. First is a minimum wage of $12 an hour, with the exception of employment in restaurant services, seasonal harvesting, and the hotel industry, which has a minimum wage of $9.80 an hour. That's sometimes known as tip wage. You're also entitled to paid training. They can't ask you to come in for training and not be paid. If an employee is working for minimum wage, the rule is that the employer has to supply any special clothing required free of charge, so a uniform. However, if the employee makes more than minimum wage, the employer can deduct a certain amount from the employee's salary to pay for the uniform. But the amount deducted must not reduce your salary to an amount below minimum wage. Additionally, when the clothing you wear to work identifies you as an employee of the business, the employer must provide it for free, no matter what your salary is. Finally, after 5 hours in a row of work, an employee is entitled to a meal break of at least 30 minutes, but the employer does not have to pay for them. Additionally, the law does not oblige employers to give coffee breaks, but employers who give one must pay employees for this time. An employer can decide the length of a coffee break. So Sam has read over his contract and made sure that it respected all his basic rights. However, one clause in the contract caught his attention. It is the Noncompete Clause, which says that Sam is not allowed to work for any of his employer's competitors at any point after the end of his employment. This concerns him as he only intends to keep his job for the summer and does not want to commit to anything long term. Sam wants to know if this clause is legal. So some non-compete clauses are indeed legal in Quebec. However, they are regulated and cannot be too broad. So non-compete clauses need to be clear, unambiguous, and in writing. The clause must be limited in duration, location, and scope of employment. And the extent of the clause's application must not be more than is necessary to protect the interests of the employer. So in this case, is Sam's non-compete clause valid? And the answer is no, because the clause does not have any limitations in duration or location. The clause said that Sam cannot work for a competitor at any time, and it does not specify a location where it applies, for example, Montreal or the province of Quebec. This is a strong indication that this non-compete clause is not valid. That means that even if Sam signs the contract, the clause will have no effect. So Sam has told his employer that the non-compete clause is not valid, and his employer has agreed to remove it from the contract. However, Sam is now worried that the employer will want to retaliate somehow because Sam is making things difficult. Sam wants to know what his rights and obligations are. So an employer has several obligations. An employer must protect an employee's health, security, and dignity. They must allow the execution of the agreed upon tasks. They must pay the agreed upon salary. They must provide a clear and explicit employment contract. And they must respect the Act Respecting Labor Standards, or the ARLS, in terms of sick leave, maternity and paternity leave, etc. An employee also has obligations. They must act with honesty and fidelity. They must do their work prudently and diligently. They must be able to execute the agreed upon tasks. And they must not use confidential information obtained during their employment. So Sam's friend Jonathan would like to get hired as a driver by the company that Sam works for. However, he told Sam that a few years ago, he was charged and convicted for driving under the influence. Jonathan is worried that the company will refuse to hire him because of his criminal conviction. Sam tells Jonathan he doesn't think the company is allowed to do that because it would be discriminatory. Is Sam right? So you can see here the grounds listed which are protected from discrimination in the employment context in Quebec. It includes most identity factors that you would expect, like race, sex, religion. In addition, an employer is prohibited from dismissing, refusing to hire, or otherwise penalizing an employee on the sole basis that they were convicted of an offense, if the offense is in no way related to the employment, or if the person received a pardon. One should be aware, however, that a distinction, exclusion, or preference based on aptitudes or qualifications required for the job is not discrimination. So in this case, Jonathan is applying for a position as a driver, and he was charged and convicted for driving under the influence, and has not received a pardon. The company may thus refuse to hire him solely on this ground. Sam's employment contract also specifies two things. His employment is for a fixed term of 4 months, and he is entitled to 7 vacation days. However, when Sam signed his contract, his boss told him that he would prefer if Sam did not use his vacation days, because the department Sam works for is going to have a lot of work this summer. Nonetheless, halfway through the summer, Sam felt like he needed a break and used his 7 vacation days. When he returned to work, his boss told him he was letting him go because he felt that Sam was clearly not working hard enough, since he took his vacation despite being told not to. Sam wants to know if his boss can fire him for using his vacation days. He also wants to know why he wasn't given a notice of termination. So Sam's boss cannot dismiss him for taking vacation days. The law is clear. No employee can be dismissed for having exercised their rights, such as going on sick leave, maternity leave, taking a vacation, etc. Moreover, employees under a fixed term contract can only be dismissed for a just and sufficient cause. So Sam has also been at his job for less than 3 months. And as you can see from the table on this slide, this means that his employer doesn't have to give him a notice of termination before dismissing him. This is also the case for employees with a fixed term contract, and an employee is dismissed for a serious fault. Lastly, if you ever want more information on this area of law, the LICM offers a Just Info presentation on employment, or if you have a specific legal info question about your work situation, don't hesitate to contact our legal information branch. That was all for today. Catch us next Monday for a short video where our Director of Student Advocacy and University Affairs, Peter, will tell you all you should know about your student rights at McGill.